Mack, I think we are now live and we are good to go, my friend. How are you doing today?
I'm doing pretty good. Sitting at a conference most of the day, but it's always good to learn new stuff.
Well, we appreciate you making some time for us. This is our monthly Alabama Work Comp Today. David and I have been doing this since September, and each month we try to bring to you guys news of national interest, news of Alabama case law, and we're starting to bring on some of our friends from different parts of the country. And our friend today is Mack Babcock. He is out in Colorado, works out of Denver. Mack, if you would, and I appreciate you stepping out of your conference for a little bit to have some time with us, but if you would, tell us about yourself and your practice. What do you guys do out in Denver?
Well, I've been practicing law for, I guess I'm in my 18th year. I graduated law school in 2002. Fairly typical story, although I think you guys are a little bit different. My first job out of law school was as a defense attorney. I spent about a little bit over 5 years representing insurance companies and employers. Did a lot of workers' compensation defense. I did some general liability and personal injury insurance defense stuff. Decided I didn't want to represent insurance companies anymore, and wanted to have my own business. And so I left that practice, switched sides, and I've been doing claimants plaintiffs work for the last 13 years. And I worked for another firm for a short time and have had my firm for most of that. Our practice is about 70% workers' compensation cases, all injured workers or their families. About the other 30%, most of that is personal injury work, car accidents, product liability, premises liability falls in accidents on people's property, construction accidents, that sort of thing. And then I also do some insurance bad faith work. Lots of people don't know what that means, but when certain insurance companies misbehave more than they typically misbehave, they can be sued either federal or state court for the damages caused by their obnoxious conduct, and oftentimes penalties and sanctions and that sort of thing. And so we do a little bit of that as well.
Well, it sounds like you got a varied practice. Now, David, you and Mack have known each other for a few years now. Let's talk about that organization that all three of us are now a part of, but you guys have some real responsibilities within it.
Yeah. So after joining the Workers Injury Law Advocacy Group, that's when I met Mack, and haven't been able to get away from him yet. Mack, do you want to talk a little bit about Willig and what your role is this year?
Yeah, so I've been involved with Willig for, I guess I want to say about 5 or 6 years now. David and I met at one of their annual conferences. I think the first time was down in Scottsdale, Arizona. Willig is an organization, a professional organization for attorneys that represent injured workers in different types of cases all across the United States. So there's certainly a lot of state workers' compensation lawyers, but then we also get people that do things like longshore that represent longshoremen, and people that do defense-based act work that represent government, Department of Defense contractors who are injured overseas, and different types of unique practices and that sort of thing. Willig is an interesting organization and a really great organization to be a member of, just because I find it incredibly helpful to meet people from across the country that do what I do, but under a different set of laws, and to be able to think and compare, how different states and different laws work. The other thing that is a reality is that on the other side of us, the insurance industry, the people like the chambers of commerce and employer groups that really want to minimize the claims of our injured clients, sometimes without a care for what happens to our clients and their families or not. What we see a lot of is that they'll try some bad idea in Oklahoma, and all of a sudden when it works in Oklahoma or Texas, they want to bring it to Utah and Colorado and Alabama. And so Willig, Workers Injury Law, we call it Willig, Workers Injury Law and Advocacy Group, is really the organization that is on the forefront of watching across the entire country what's going on, David and I were both board members. We were co-chairs of the annual convention year and a half ago, and put on one of the educational conferences that focuses on a lot of these national issues and that sort of thing. And so it's a great organization. I'm currently an officer in the organization. I'm the organization's treasurer. Last year I was the secretary. In 2 years, I will have the distinct honor and good burden, but still burden of leading the organization and hopefully about 1,200 members across the entire United States in terms of our mission of protecting injured workers on a nationwide scale.
Is it true that you're putting in for a trademark to change your name officially for that year to El Presidente?
Yeah, well, I have asked, I think you guys both know that being a rough teen for my parents growing up in Chicago, I was asked to move out of my parents' house as a young man. And as a result, made the very, very wise decision to find some maturity by enlisting in the United States Marine Corps right out of high school. All told, I spent about 9 years of combined active and reserve time. I stayed in reserves through college, and right before I started law school is when I decided I couldn't do it anymore. But as a United States Marine, okay, I think that I am allowed to ask that when I enter a room that they play "Hail to the Chief" and that everybody stands, right? And so we'll see if we can make that happen.
Well, I know at one of the board meetings coming up, that'll be on the agenda, I suspect.
Yeah, right.
I know we've got several people watching. I want to apologize to you guys because on YouTube, I don't know how this happens, but they change up their analytics and how they do things. There's no comments that can be given in the live viewing today, but you will be able to comment after the fact. So thank you for hanging in there with us. And
one of our Willig friends is watching live. I want to say hello to Ben Gerber at Gerber and Holder in Atlanta. He's a Willig board member and a good friend of ours. Ben, thanks for joining us today.
and a former guest on our show.
Well, and Mr. Gerber and he is in addition to being the treasurer for Willig, I'm also one of the chairs of the membership committee, and Ben is on that committee. And we just finished up our first membership committee call just before joining you all for this.
Okay. Well, thank you for carving out some time, but let's go ahead and dive into this month's episode. And as we do at the beginning of each episode, we try to find articles from around the country that deal with employers, employees, employment settings, independent contractors, anything to do with a person getting hired for wages that makes some news. So we've got about half a dozen different topics, all different parts of the country and different topics that we want to dive into. And with the eve of the Super Bowl, we're going to jump off with the first case. This is first situation that we've got is out of Pennsylvania, and it involves a former Steelers linebacker who was injured on the job. And the title of the article, and again, I'll put all the links to these articles in the show notes, ex-Steelers linebacker wins workers' compensation battle. And guys, I'll throw this to you guys, but what really interested me was the issue that turned about seasonal employment versus someone who is contracted to be a year-long. Now, Mack, I know you've got that issue in Colorado. We don't have as much here. But let's talk about the case and then let's see what Colorado has to say about that.
So we see this argument all the time in Colorado. Obviously, we have a lot of seasonal employees here with the ski resorts, the rafting companies, the fly fishing outfits, the mountain guides, that sort of thing. And so you'll see people who either come to Colorado and work for a season and then leave, or maybe it's somebody who works that season and they have different employment in the summer. Where this argument comes from, right? It affects the wage loss benefits, referred to as temporary disability benefits in Colorado, probably the same in Alabama, as they are in most states. That they ultimately what they want to do is, yes, they want to reduce the cost of the claim, okay, by paying less in wage loss benefits, but also what they want to do is, in a really nasty way, starve out an injured worker. And so they'll make one or two arguments with the seasonal employment. What they do in Colorado is either they say, okay, well, your season would have ended, the ski season would have ended in April. And so we only owe you wage loss benefits through April. And even though that injured worker is still restricted from working and maybe can't go to their summer job or find a new job, we're going to cut off your benefits and then starve them out and try to strong arm them into maybe undersettling their claim or ending their medical treatment. That, or they'll take 4 months of wages and say, but we're going to divide that over 52 weeks and pay you maybe a third or half as much as we normally would.
Mac, I think that's what they initially had attempted. David, what did you find out about what this football player's contract and maybe the NFLPA had to say about that?
Right. So the court ruled that it was a yearly salary. And one of the reasons is his football season may have lasted from, say September to January as far as the 16-game schedule, but his contract required him to attend camps, to work out, and to have media appearances, which were throughout the year, the calendar year. So therefore it was a yearly calendar and a yearly employee versus a seasonal employee.
And another interesting note, as part of his contract with the Steelers, he couldn't participate with any other professional organizations in his area of expertise playing football.
Right.
And the NFLPA has addressed this over the last couple of years in the collective bargaining agreement as well. But here's another interesting note about that. You can get hurt on the job and file a workers' compensation case if you're an NFL player for your respective state, but you also can file a grievance with the NFLPA that would take you through an arbitration process. Now, admittedly, I don't know much about how that part works. And Mac, I don't know if you've had any experience with that, but it seems like that they may be able to go on both tracks. But this one is just talking about the work comp aspects of the case. It made a huge difference in what he was entitled to from a compensation standpoint.
Yeah. The last comment I'll make about this case, and I don't know if you guys feel the same way about this, but I represent people from all walks of life. I've represented doctors and lawyers and accountants, school teachers, cops, firefighters, all the way down to guys that are, laborers on a construction site or whatever. Oftentimes, the more educated, maybe the more fluent, the higher wage earner clients are shocked that they get treated the same way by the insurance company that maybe the janitor or the ditch digger does. Well, guess what, guys? This guy's a professional football player. That insurance company doesn't care. They treat him the same way and make the same arguments that they do to reduce his claim that they do everybody else.
That's exactly right.
Good point. Yeah.
And Mac, we're capped depending on the date of your injury in Alabama. We'll cap, and it goes up a little bit each, July 1st, I think. Right. But you could be making $2,000, $3,000 a week. But if you get hurt, say July 1st of 2019, you're capped at, I think, $865 a week in the weekly benefits. So it doesn't matter what you do.
Right. Our caps are a little bit higher than yours. That's probably a little bit of a cost of living the difference. But the Colorado max compensation rate's a little bit over $1,000, and likewise adjust for inflation, cost of living every year.
Yeah. All right. Well, let's put that one to rest and let's move to California. We've got an issue here that we've talked about a few times on our show, and it's the California new independent contractor law, AB 5. And this has really, really been in the news for months now because it affects not just hundreds of thousands of people, but potentially millions of workers. And whether it's going to have a trickle effect into other states, I think that's what's coming down the pike. But Dave, why don't you kick off of what you know and what you've seen about this new law out of California?
Sure. Quick overview of California AB 5. This law went into effect January 1 of this year, and it created a new set of laws for California companies that work with contractors. And specifically, the law changes the definition of an independent contractor in California. And under this new law, someone can only be considered a contractor if, and there's three things: they control how they work, the work done falls outside the hiring company's usual course of business, and they customarily engage in an independent trade. So this basically codified or made into law what a contractor is defined as in California.
So a little bit more background. So a couple of things. This issue, we talked about Willig at the outset of this. This issue and the growing use of independent contractors, rightly or wrongly, largely associated with what gets commonly referred to as the gig economy. You know, all the apps and people working through the apps, that sort of thing is becoming a huge issue. It's becoming a huge issue because independent contractors don't get protections like unemployment insurance, workers' compensation, that sort of thing. You know, they're not subject to federal law when it comes to fair wages and fair labor and that sort of thing. There are implications in terms of they don't pay taxes, right, the same way that the rest of us do, and that's going to affect states' budgets and federal budgets. And so this is, you guys, I could do an hour show on this case. I don't know if you guys know that history, but the Colorado AB5 law was originally a California Supreme Court decision in the Dynamex case that changed the independent contractor test. And then they codified, and then in the next legislative session, the California legislature codified it in the AB5 law. The Dynamex case created the ABC test, which is what David just discussed. And then they codified the AB5 law and got it passed last year. They did try to pass this same test, I believe, in Oregon and Washington, maybe, and were not successful last legislative session. Here's something going on now. The California legislature is in session, and companies like Uber and Lyft and Walmart and Amazon are expected to spend something like over $1 billion in lobbying money to try and get this law reversed and taken off the books. There is a huge battle going on because, like we know at Willig, that ideas go from state to state. They know that they do for us too, and they've already seen this try to go to Oregon and Washington, and they're scared that it's going to go to other states.
Well, Mac, one of the reasons why they're really fighting this is not only the change in the status, and they'll have to provide different protections for these folks, but the misclassification lawsuits that are pending or could be coming their way could put companies out of business is one of the things they fear. So they've got to be proactive to make sure that they're in compliance with AB5.
Well, the most significant thing about this new test, the first and third elements, which is really how much is the potential employer or contractor controlling the employee or independent contractor? Is it more like an employer or employee where the employer has a lot of control over schedule and how the work's done and all that stuff? You know, and then the third test, part of the test, which is, you know, is the individual acting like an independent contractor would? Are they customarily out there in independent trade? That's a very standard independent contractor test. That's what we have in Colorado. That's what you see in most states. It's the second part is, are they doing the something that is the normal business or the ordinary business of the employer? So when you look at Uber, and we know Uber likes to say they're a technology company or an application company, nobody believes that anymore. They're a transportation company. So if you're a driver, right, that's their normal business. That's the essential function of their business. I've had lots of debates, and I spoke at a couple of conferences across the country on this particular issue last year in my role as a Willig officer. I was up in Montana and a couple of other places. If you think about that test, it could be applied very broadly, right? And so I don't know if it's a good idea or a bad idea, to be honest with you. I don't know if at the Nomberg Law Firm, do you guys ever bring on contract paralegals or contract attorneys to help you out with a big case or something like that? Well, we do occasionally, right? Under this law, do I have to make those people employees, right? If they're only going to work there for a month or two? I think it could. I mean, it's different states are trying to address this issue because of the emergence of the use of independent contractors. And so it'll be interesting to see where it goes.
Well, this is certainly not going away anytime soon. I think 4 out of our 5 shows, we've brought this up, and I anticipate it'll be on our agenda for months to come.
Yeah, I would also say that even though in Colorado we don't have the AB5 or the ABC test, and I know you don't in Alabama either, I will say that I run into bogus independent contractor classifications, misclassifications all the time, and fight them all the time and successfully. I would guess that the Nomberg Law Firm does as well. And any injured worker out there that is being told that they should not get workers' compensation benefits because they're an independent contractor should talk to a lawyer and see if they agree.
I tell you where I see it most in our practice is long haul truck drivers.
Yes, absolutely.
They're 1099 folks. But again, we could talk about any of these for long. I know we need to keep moving forward, and we're going to go to the land of cheese. We're moving up to Wisconsin. Claim where this has been in the news for many weeks now, where over 64,000 Delta employees have sued Lands End, not their employer, but Lands End over sickness due to uniforms. Now, Dave, I know that you like to wear a lot of polyester at work.
It's flattering for me.
I don't know. I haven't heard any complaints that that's making you sick, but what type of a case are these employees pursuing?
Yeah. So Delta airline employees were issued Lands End made uniforms, and the employees complained that they suffered skin rashes and headaches and fatigue and other issues, and they filed a lawsuit against the manufacturer, almost like a products liability claim against Delta. And of course, Delta,
Delta.
Thank you. Lands End. And of course, Lands End denies that there's an issue. Delta says that they conducted a rigorous toxicology study that said that the uniforms met the highest textile standards. Very interesting situation.
Mac, why do you think they did not sue the employer?
Well, and so I was just going to say, we talked about my practice at the beginning, and that I do both workers' comp and personal injury work. We get a lot of potential clients who contact us who don't understand that in exchange for providing workers' compensation coverage in most states in the United States, and I know it's true in Alabama, that it's certainly true in Colorado, that in most states, in exchange for providing workers' compensation coverage to employees, that is no fault coverage, that you don't have to prove the employer did anything wrong, that they caused your injury, that they were negligent, did something else to make your injury happen, that they automatically have to provide you workers' compensation benefits with coverage with certain benefits that are mandatory, medical, wage loss, permanent at the end of the case. But that in exchange for that, you cannot sue your employer for a traditional personal injury suit, even if they were at fault, even if they were negligent, and that they have what's called immunity from personal injury suits. Being it's a little bit unusual in Colorado to have an attorney that does both workers' comp and personal injury. And so a lot of my personal injury practice is this type of thing, where we have a workers' compensation client, but then also has a personal injury case that arises out of the same incident. While you can't sue your employer, they're immune. If your injury is caused by a non-coworker third party, right? Somebody who doesn't work for the same employer, you can sue them or file a claim for a traditional personal injury, bodily injury claim. The most common thing we run into is car accidents, salespeople, truck drivers, people who get in accidents while working. They get both workers' comp and they have a bodily injury claim against the responsible driver. But we get unique situations like this is really, as David said, a product liability case. And so, when people get hurt, they need to, talk to their attorneys and say, okay, I understand I have a workers' comp case, but what else? We've had people, and I'm sure you guys get this in Alabama, who are injured at work, they're getting medical treatment, and then their doctor or a hospital commits medical malpractice, right? They continue to treat under the workers' comp case, and the workers' comp insurance carriers to continue to pay for the fallout from that malpractice, but then they also have a claim against that doctor, against that hospital, that sort of thing. And this is a very unique circumstance because it is product liability.
It is, and you've got two very high-profile corporations who've done business around the world for decades. So there's a lot at stake right here, but we'll come back to this case in the upcoming months when there's more news about it. But anything else, Dave, you want to contribute? All right, let's head east. We're going to head to Connecticut. And this is where the robots are just taking over. And the issue here is about robots taking over warehouse big warehouse situations. And two things are really happening. One, people are losing jobs. And two, those who are there and having to interact with these robots are getting injured in a way or in ways that they never anticipated, probably when they first were hired on with the respective companies. And
Yeah.
Mac, do you guys have large companies like Amazon and those type that are out there that?
So we don't have as much manufacturing in Colorado as you do in other places. But you know what I took away from this article, and I think it's a common theme, not just in manufacturing but across all walks of life, that we've created all this technology to make us more efficient, more flexibility in the way we work and the way we do things. And what's kind of central to this article is talking about, like, the robots are supposed to be doing the more dangerous, more mundane aspects of these jobs to make it safer, but they're creating new issues. I don't know about you guys, but I feel like technology creates health issues in my life. Wouldn't you guys like to go back to practicing law before email and before you could get 100 emails in an hour in your inbox, right? I don't know, that there's a conversation that I think we all need to have about whether or not technology is adding to our lives or detracting from it. Large corporations, and this talked about Amazon specifically, and the robots in their warehouses and that sort of thing. We see it a lot with corporations that are after maximizing that profit, seemingly minimizing costs in terms of injuries and labor costs and that sort of thing. It would be nice to see a broader conversation about, is this really good for us? Should we really be going faster? Is bigger and better and faster really better, right? Because there's these types of things that happen that people are still getting hurt.
Dave, I want to share this with you. There was a study that did as part of this investigation that was made the basis of this article. They looked at records from 28 Amazon warehouses in 16 states and found the overall rate of serious injuries was more than double than the typical warehouse industry average. That's remarkable.
Well, and that's, we love ordering something online and you have it in 12 hours or within 24 hours or 48
or 2 hours if you're in certain parts of the country.
That's right. And so while we talk about Amazon frequently on this show, just because it's the 800-pound gorilla, and they're meeting customer demands, but it's also causing more injury to their employees. And we love the efficiency and the promptness of Amazon, but there's a rising cost to that, and that's injured.
And with any warehouse environment, you're going to have injuries. It's just part of owning that type of a business. But now you've got these extremely heavy machines that either are working on their own accord or have humans running them. But as it said in the article, one of the employees said it's kind of creepy or eerie. Sometimes you don't hear them and they're up on you before they realize it. And that leads to some really bad situations for some workers.
This is not going away. In 2014, Amazon had 15,000 robots, or drives as they call them. At the end of 2019, they had 200,000.
Wow.
So
well, and here's another interesting thing about Amazon and some of these companies that are really pushing efficiency in search of overwhelming corporate profits and things like that. Tying back into the previous article, Amazon is on the forefront of pushing these independent contractor things. So guess what? They can have all these injuries, David, with their dangerous warehouses in the search of corporate profits, and then characterize all their drivers and all their workers as independent contractors and not protect them. Right? You're right. I like home delivery, and I'm an Amazon Prime member and all those things, but not if it's going to cost people their livelihood and their health and their,
Well, while we're talking about misclassification and that earlier situation about AB5 out of California, that leads us to this next article, which we should have talked about then, out of New York. And the title is Lyft offers to settle New York driver classification disputes. Now, this was from 3 weeks ago. I did not follow up to see if there's been another one since then, but this ties into exactly what we were talking about, the problems that potentially that these large corporations find, that if they're not proactive and figure out how this law works and then fall within the parameters of the law, millions upon millions of dollars are at stake here.
Here's an interesting thing. So I read the article and it talked about the offer to settle the misclassification lawsuit was that they were going to pay $600 per driver in this class action, and that the class is estimated to be 8,000 people. Now it talked about that the lawyers handling at what we call the steering committee, the head lawyers directing that lawsuit, right, are advising the drivers to turn down that lawsuit. The lawyers don't get to make the decision. They have to go to the class members and have them on to vote on whether they want to accept this or not, because they don't think it's enough. If you do the math, they say the class is about 8,000 drivers and it's $600 per driver. I did that math. That's about $4.8 million. Okay. Do you think Lyft has made more or less in profit than $4.8 million by misclassifying their drivers and not providing workers' comp coverage, not providing unemployment, not providing health insurance, not complying with federal and state minimum wage laws, right? Not paying taxes. Lyft has made billions, right? Based on not having to follow federal and state law.
Did you hear, David?
What?
They've probably made 4.8 million since we started this show 30 minutes.
Yeah, that's exactly right. And so, I don't, oftentimes, I'm sure it's true for you guys, that oftentimes we see some of these lawsuits and we know the attorneys involved because we go to conferences and conventions and speaking events and that sort of thing. I don't know these particular attorneys, but good on them. $600 per driver does not make up for not paying taxes properly, not following minimum wage laws, not right. I mean, and Lyft is notorious for the guys sleeping in their cars, right? Not earning a living wage.
Some of those who hustle, maybe college towns, I don't know, who drive for Lyft or for Uber, they could make $500-600 on a given night. I mean, it really doesn't represent much money, but
right.
Let's pivot to our last article today, Mac. We're coming down south. We're coming to Tennessee. And this is dealing with truck drivers. Again, seems like we're picking on Amazon, but they're one of the biggest employers now in the country. And there's just so many legal issues that seem to surround some of the things they do. And the quote here is, like a rented mule, was the description for this truck driver who was so exhausted before he had a crash. So Dave, what did you take away from this article?
Yeah, so this truck driver filed a lawsuit in Tennessee. Interestingly, the article says he is representing himself, that he does not have a lawyer, which will be interesting to see how the case proceeds. But he's saying that as a contract driver, he was forced to drive more than federal law allows. Federal law says that drivers are only allowed to drive a certain amount of time before they have to take a break. And he says that he far exceeded that. So he's actually suing for negligence and violation of federal drive time laws. And he ended up having a tractor trailer crash. And so he sued after the crash.
Mackey
says
said,
he was exhausted.
Yeah, Mackey said he was on the road 49 hours without a proper break. And he is filed in federal court, sued Amazon and its contractor, AAA Freight. He's probably lucky to be alive, but what was your take on this one?
Well, as David pointed out, and I know we were talking about this a little bit before we started the show, but he is representing himself. We talked about the Delta Airlines case where those employees were allowed to sue Land's End but they couldn't sue Delta for the uniforms because of workers' comp immunity. My concern here is that this guy, good on him for calling out what sounds like really bad behavior, but I'm concerned that really he's got a workers' compensation case, but that he's not going to be able to sustain a suit for his injuries against his employer Amazon and this AAA, the Contractor. It, again, good on him for calling out bad behavior. One of the, workers' compensation is one of the, it is the largest social safety net that came out of the labor revolution, industrial revolution in the early 1900s, to when laws were passed to protect workers, to provide a safety net, to provide safe workplaces, and that sort of thing. There's lots of good about it. It's no fault. Your employer is required to provide it. Should get paid more quickly than trying to pursue a personal injury case and that sort of thing. One of the downsides is that it does, because the employer gets 100% immunity in most places. That's not true across the entire United States, but in most places, it's true in Colorado and Alabama, that it does, they do get away with bad behavior some, and then all they have to pay is a workers' compensation case. Some states have changed their laws that says that if you can show that an employer acted with, something more than negligence, willful and wanton conduct, reckless disregard, that you can pursue them. I don't think Tennessee has that law, but I could be wrong. But it's this type of situation that is why states have started to make those exceptions so that an employer can't do this type of conduct and just get away with it.
I'm wondering if he survives a dispositive motion here, a motion to dismiss or summary judgment, if his injuries are enough, maybe he'll pick up counsel that may run with it and help him toward the end of this case.
Right. Yeah. I don't know if this gentleman looked for an attorney. We get calls, as I said before, of clients all the time that don't necessarily understand what their rights are. And he may be somebody who called around and was told that you can't file this type of lawsuit, decided to do it anyway. That would be unfortunate. He's obviously calling out, again, bad behavior in the search of corporate profits. It's
Well,
That's one of the services that we provide, and I'm sure you do too, Mac, is that we help explain to injured workers what their rights are and what they're not. And so often we'll get a call from someone who's been hurt at work, and really they're calling us about a work comp claim, but they want to talk about the employer's negligence, what the employer did wrong, what the employer was at fault about. And pretty much every time we have to tell them, sir, you got hurt at work, your claim is against your employer for work comp. And the liability, the negligence does not enhance the value of your claim.
You're right. And Mac, I bet you have this experience. A lot of times it's all about emotions and personal relationships and people's feelings getting hurt. You got to explain through all of that it's business. When you're working for the company and you're producing and the company's doing well, you're the man. You are awesome. But as soon as you get hurt, you get kicked to the curb because they've got to replace you, whether it's part-time or
you're a cost, right? No, very, very much so. And I explain to clients a lot, really, and it's not just workers' compensation cases. It happens with bodily injury, personal injury cases as well, that these are compensation systems, and that where their focus needs to be is, let's get you back to health. Let's get you back to work. Let's avoid financial catastrophe for you and your families. Yeah. I do get clients who, maybe they've worked for some of the not so nice employers, Walmart and Amazon and some of these, and they want to make a point and have their day in court or be heard or whatever. And a lot of my job is counseling people and making them understand that, because listen, Walmart and Amazon and all these companies, we've talked about some of these cases, they get tagged with multi-million-dollar verdicts regularly. Does it change their behavior? Not really. No. Do they feel bad? Do they feel bad about themselves? No. And really what we do is protect individuals and families and try to get them to a better place in their lives. So
for those of you just joining us, thank you. I should have done this a few minutes ago. This is our monthly show, Alabama Work Comp Today. David and Bernard here out of Birmingham, the Nomberg Law Firm. And as we have on our guest today is our buddy Mack Babcock out of Denver. And we're talking, the first part of our program today is we've talked about 5 or 6 different news-making situations that involve employers, and it's big businesses and small businesses, Amazon, Delta. Who else have we done
Man's-
here today? The
Uber,
NFL.
Lyft, NFL.
Yeah, so it's all over the country. These different, just because they're out of one state, it may still affect you in another state. But this part of the show, we now are going to transition, Mac, and talk about, we're going to do a little comparison about how certain parts of the Alabama work comp laws in comparison to Colorado laws. Admittedly, our laws are over 30 years old and they are outdated, they're antiquated, and don't fit with the current cost of living, not even close. And we won't get too far into that today because that could be a whole show on its own. But the purpose of bringing this up, and I know that Colorado's laws are a little bit more progressive and a little more modern than ours are, and we just want to show a little comparison here.
Yep.
So Dave, explain what is mileage reimbursement in the context of Alabama work comp?
Sure. One of the benefits that an injured worker receives under Alabama law is reimbursement for their mileage when they go to the hospital, the authorized doctor, physical therapy, or go pick up prescriptions at the pharmacy. And I think our current rate, and it changes every year, I think we may be at about 58 cents a mile right now.
57 or 58 cents
Yeah.
a mile.
So the injured worker submits a list of all the places they have been. They send that into work comp, and then they get a mileage reimbursement check for travel to the medical providers.
And you got 1 year to do it from the most recent or the oldest time out that you've been to the doctor or wherever you've been. It has to be for authorized care. And sometimes there's a discrepancy when the adjuster is calculating the mileage versus what our client may have sent in. And typically I have seen that either Google Maps or one of the recognized maps companies, as opposed to our client, watching it on their pedometer. But Mac, talk to us a little bit about how does Colorado treat that?
So it's, sorry. It's the exact same thing. The idea, one of the aspects of workers' compensation, I think true in Alabama, Colorado, and other states, is one of the very common aspects is that, they're trying to avoid, it's a protective system, it's a compensatory system, and they're trying to not create a financial catastrophe for the injured worker and get them back to work as quickly as possible. The medical coverage under workers' compensation, unlike what you see with health insurance or Medicare and Medicaid, one of the really differences is that it's not supposed to cost the injured worker anything. No out-of-pockets, no co-pays, no deductibles, no co-insurance, right? Stuff that would not normally be covered by health insurance gets covered by workers' comp in Colorado. Mileage reimbursement is a medical benefit, right? In Colorado, it's part of the medical coverage because they don't want you to have to pay for the expense of going to your doctor's appointments. And so they do mileage reimbursement here. If that's not going to work or you can't drive, you broke your legs or whatever, they provide transportation services and that sort of thing. It's interesting. Our reimbursement rate is lower than yours, 53 cents this year. It does adjust. It actually went down. They look at the cost of transportation in Colorado. And so as gas prices go like this, I think it was 56 cents last year, and now it's 53 cents for 2020. And so it does fluctuate a little bit, much higher than what you see in terms of the IRS medical reimbursement rate or tax reimbursement rate. I don't know if you guys have run into this, but the insurance companies, we talked about the seasonal employment with the NFL guy and how insurance companies use that to try and starve people out, make the system difficult, maybe, help force people out of the system or give them motivation. They love to screw around with mileage, especially with my low income clients. We're actually the trial bar here this year, the workers' compensation trial bar. We've got a state group that we work with, organized labor and other groups to push, pro injured worker, pro labor legislation. One of our pieces of legislation this year is to stop these games. And so we're we did not have specific timelines before. And now we're making it that you have to submit your mileage within 180 days. So about 6 months. Okay. But that once you submit it, the insurance company has 30 days to pay it or deny it. The 30 days that lines up with their obligation to pay other medical bills timely. That 30-day timeline is the same for paying your physical therapy bills and that sort of thing.
We have a similar provisions.
Yeah.
Well, along those lines, let's talk about pharmacies in the work comp dynamics. We actually had a case, 10 years ago. I don't remember how long the
That's about
Williams
right.
case was,
Yeah.
that the insurance companies were trying to dictate what pharmacy and limit you to what pharmacy you could use. Well, the case went our way, and you're not limited so long as that company, or excuse me, that pharmacy can provide that type of medicine and has a contract with whatever or accepts whatever work comp coverage company that there is. And is there something similar, or do you have provisions in Colorado like that?
We have not had, we don't have a specific thing in terms of a statute or a regulation, but we do have insurance companies who like to try and send people to specific pharmacies, or really they'll contract with a national pharmacy provider who will do, mail order or that sort of thing. They try to get injured workers to use their preferred provider, one, for additional discounts that provider is going to provide to them. We're also seeing stuff where the insurance company picked provider will automatically substitute generic medications when a provider may have written it for a name brand medication or an alternative medication. We see them doing things like sending letters to doctors and providers suggesting cheaper, lower cost medications or different medications, or suggesting that they cut off certain medications, that sort of thing. And so attorneys here have engaged very, very much in what it sounds like the fight you had 10 years ago that says you're not all, if the injured worker agrees to use your pharmacy, great, but the injured worker is also free to pick any other pharmacy. And it's really been through case law, right? Judges' decisions and things where we fought that battle. So it sounds very similar.
You got anything to add to that, or we kind of covered all that?
No, that's just, it's good that the employee has the option to either go pick up his medication or have it delivered to the house. They don't have to leave the house. Yeah. But then sometimes you worry about when it arrives and whether it gets stolen. So there's issues on both sides of it.
Yeah. Well, guys, we're going to transition into our last topic for today, and we're still talking about Alabama law, and we're comparing it to how Colorado law operates. And this is really one of our biggest areas of contention sometimes in our cases, what usually can lead to litigation. And it's the coming and going rule, as well as the exceptions that help in those. And Dave, why don't you explain a little bit about the coming and going rule?
Sure. In Alabama, if you are leaving your house and you're on your way to your job, say it's at a factory or a warehouse, and if you're injured in an accident, usually that's not going to be covered by work comp.
Right.
Okay. Same thing. If you leave your job and you're on the road going home, that's probably not going to be covered.
Yeah. You're off the clock.
You're off
in
the
both
clock.
of those situations.
Now, some of those exceptions are if you're in the company parking lot and you get injured, that might likely be covered by work comp. Or even if you had just clocked in or just clocked out and you're still on company property, you're still so close to in the proximity of having just finished working or about to start that's probably going to be covered. But again, leaving work and off property or on the way to work, probably not covered under work comp.
Another scenario that I'm thinking of is if you're assigned a company vehicle and you are on call, so to speak, that could be a situation of an exception where you would be covered. Mack, I'm sure you guys have these issues as well. They probably are very specific arguments, but talk to us a little bit about your experience under Colorado law.
And so like it is in Alabama, we have the general rule. I mean, it's called the general going and coming rule. And that is that commutes to work or commutes from work are not covered. Then there are exceptions to that. And there's a test that gets applied from a Supreme Court case that we had here in Colorado in 1999 that set the test for the exceptions to the going and coming rule. And basically what it says is things like David said, in terms of like the parking lot exceptions, that if you're close enough in proximity to still be considered within the scope of your employment, things like you're still on the company property, you're walking into the company parking lot, that's still going to be covered. There are also cases where travel is contemplated as part of the employment relationship. or that it is done for the benefit of the employer. And so, for example, there was a case a couple of months ago. It was actually an attorney that worked for the city and county of Denver, prosecutor. Okay. And she left her house in the morning. She was driving right to the courthouse. She wasn't going to her office, and she was driving right to the courthouse. Okay. And she got in a car accident, and that injury was covered. It was covered because it wasn't the normal commute, because she was going, and so that type of situation is going to be the same for the plumber who has a plumbing truck from his employer, and instead of going into the warehouse in the morning, goes right to his first job, that sort of thing. And so we see these exceptions with salespeople, people who are in their cars a lot for work, situations where people, the foreman is picking up the 3, coworkers before they go to the job site, that sort of thing. Interestingly, this issue is starting to overlap significantly with the independent contractor stuff, because the way we all work, okay, and the way we all interact with our employers is much different today than it was when workers' compensation laws were put into place, right? We could have just as easily had done this show on a Saturday with me sitting next to a pool and you guys sitting on a golf course, right? And if we all got hit by lightning, is that covered by work, right? And so it's becoming the old hard and fast rules in terms of what is and what is not work. Is getting very muddied. I had last point. I had a guy who was on the weekend wearing flip flops and board shorts. He had stopped at his office downtown. He was leaving the office. He was going to go back home to pick up his kids and go to their soccer game. He was on his cell phone talking to a client. He was a financial guy or something like that. He was crossing a crosswalk and got run down by a car, right? He was unfortunately, he was killed by the other driver. Workers' compensation coverage was originally denied, but we got the cell phone records. We had the person who was on the other line that was a client say yes, he was he was working, he was on the clock, and so that's a very unique situation. But
those are definitely fact specific situations every time.
Yeah,
well, Mac, we could talk all day. We appreciate your time.
Yeah.
I hope that we've covered everything we wanted to today. Dave, you got anything else to contribute that we hadn't covered?
Special shout out and recognition to Ben Gerber in Atlanta. He's been watching the whole time, and he asked for recognition. So you're welcome.
Well, and again, we're sorry that the settings for our YouTube didn't permit comments, but maybe that was for the best today. But we do the end of each month. We try to come to you the last Thursday of the month, Alabama Work Comp Today, where we address national cases of interest and situations and newsworthy matters. And we try to bring to you how Alabama treats certain situations, certain cases. And we've had our good buddy Mac out in Colorado with us today. So Mac, thank you for your time and your expertise today.
Well, I very much appreciate you guys having me. It takes a big risk to have a guy that talks too much anyway. And so I appreciate that, but I'm very honored to be invited, and I enjoyed it.
We certainly appreciate you, and we hope to break bread with you in the upcoming months when we see you again.
All right, guys.
And this is the longest show that we've had, almost at 60 minutes. And so there's no doubt that was going to happen with you on the show.
That's good stuff.
You knew that was risk.
Guys.